Is up, everybody? Welcome back to another week of the GZ Chop Shop Gaming Podcast. I am your host, Greg, and I always have to have an amazing episode lined up for you guys. And today, I am joined by the founder and managing partner of Gamma Law. With a career spanning nearly 3 decades, this gentleman has become a recognized authority on emerging legal issues, working with some of the world's largest corporations, including those in video games and eSports. Let's welcome David Hoppe to the podcast. Welcome to the podcast, David. It's an honor to have you.
Thank you, Greg. Likewise.
So, growing up on video games, I can tell you, as a kid, I didn't think video games had laws. You get your game, you play your game, and you don't really think of everything that's happening behind the scenes, and especially the legal intricacies that are happening behind the scenes. But how did you in particular become involved with gaming law? Like, how does that even happen?
Yeah, so for me, it was a bit of a winding and you could say serendipitous path. I did not set out to be a video games lawyer. Initially, my target was to work internationally as a lawyer, particularly in Japan. And so I was able to do that for a few years. And somehow in the course of that experience, I was able to make some connections there, working for a large law firm, and later in New York, working with Japanese clients. And one of those connections ultimately would reach out to me after I had been out to Silicon Valley during the dot-com boom, which is a term I don't know how many of your fans may be familiar with, but that was the early days of the internet, and everyone was throwing money at these internet companies, Yahoo, and so forth. Eventually, Google, this company, came along as well, and largely dominated the space that we were in. In any event, I did that for a couple of years, and the company I'd worked for out there ultimately went bankrupt, even though it was a NASDAQ-listed company. Stayed around for a year and helped them take apart their operations, and then after that started the practice that I'm with now, which is called Gamma Law, as you mentioned. But initially, I envisioned this practice as a sort of similar to what I had been doing before with large law firms, finance, U.S. market entry, principally working for Japanese and international companies. But then that opportunity came along when the contact that I had mentioned before reached out to me, and he had since moved to one of Japan's premier video game companies. And he got my newsletter or something and reached out and said, we're starting. He was in Tokyo. He was an executive with that company. And we're setting up a new business unit in LA. They're going to do license in mobile game content, which was like, what an exciting concept at that time.
Yeah.
Even just mobile games was a revolutionary concept at that time. So anyway, to make a long story long, as it were, that was sort of my start and eventually our start as we grew our team. And today we represent most of the large Japanese game publishers in one way or another. Everything ranging from licensing content to financing to eSports to film and TV licensing and a bunch of other stuff.
Wow. Okay. Yeah, that's pretty extensive. Now, you mentioned eSports. As someone who pretty much only has watched a few eSports things, what are some of the legalities that happen behind the scenes for eSports? Like, I'm completely unaware of what happens behind the scenes. So if you could enlighten me a little bit.
Yeah. So esports is it's kind of its own thing in terms of legal practice. I mean, esports are, in large part, they are public performances. And the client that we were working with was participating in some very large tournaments in Las Vegas and elsewhere. And then they had their own tournament circuit as well globally. So there's a whole bunch because it's an in-person physical performance. And so in some ways and this is, I think, one of the interesting things about video games law is that, here's an example. I mean, you have to touch so many areas and have some competence across everything from, we had to negotiate agreements with the venue. As in one case, a pretty high profile esports special purpose venue. In other cases, it could be large auditoriums. But I mean, I never I never done like a venue agreement before, and in when I was with large law firms, or when I was in house. So there's that. You've got the media agreements, which can be quite complicated. You may have agreements with talent, kind of media talent, as well as the talent on stage, which is the esports teams, the esports individual players, the esports organizations, and then you got the sponsorship agreements, which is the lifeblood of these of esports. And how is their brand going to be displayed, and what kind of mentions are there going to be, and et cetera, et cetera. And you have media rights, in addition to the live media, of course. Then you have the aftermarket, and perhaps serialization or whatever it is. Uh, and then I mean, I could ramble on for a while here, but in esports, of course, unlike conventional or traditional sports, there's an IP owner. There's no IP owner for football. There's no IP owner for baseball, even though those leagues, like to maybe pretend that they do own the game. But yeah, so you gotta, whether it's Activision or Sega or Capcom or whatever, the publisher has to be behind the effort, and they have to provide all the licenses you need to display their content and etc.
Okay, because I was going to say, like, why is there, the IP owner involved? But I guess because it's their game being played, and then they have their own, you know, legal, I guess you could say, lineup for the tournament and everything. That makes sense. Now, my other question, when you were talking about all those different entities being involved, the players themselves, are they represented by like one legal person, or are they able to come in with their own individual lawyer? Like, how does that work per team?
Sure. Yeah. So when you're working for an esports org, which we did for a period of time, then you do have to deal with individual esports athletes. And, that's a whole other challenge in itself, because sometimes these individuals may be, minors.
Mm-hmm.
They may need immigration support to come to the US for tournaments. And, there has been, as you certainly are aware, over the last few years, kind of a backlash, I guess, against the esports organizations in terms of treatment of the athletes, and the compensation and what that career path looks like for an esports athlete. Yeah, there's a whole bunch of other issues. But sorry, to answer your question directly, typically we wouldn't see uh, representation on the other side of an agreement with like a whatever it is, 16, 17-year-old kid that's been invited to kind of go to the esports house, maybe on a trial basis, or whatever it is. you know these are kids that, first of all, they're kids, but second, they're kids that have been really probably focused on this for many years, but really haven't had the opportunity to make any money from it. And when that opportunity comes along, then of course there's a huge motivation to just sign whatever's presented, so that you can take advantage of that opportunity.
So, what would be some advice you would give to parents who their kid might be wanting to get into esports and aren't aware of, you know, what will potentially be coming their way?
Yeah. Well, I don't know. I mean, as a parent myself, I'm not sure that it's a course that I would necessarily kind of advocate for, certainly, at least as the kid's, principal, or instead of, getting a good education and opening some other opportunities as well. But,
Yeah.
you know, certainly as a parent, I mean, you want to make sure, let's say the kid does have some real talent and has some kind of stage presence, and, is able to really advance and stand out. You don't want him or her to be kind of locked down for an extended period of time, with terms that may not reflect their value as it grows. You don't want the ability to, you don't want them to be kind of locked into a particular organization for a period of time that, for an extended period of time. And you don't want their name, image, likeness rights to be tied up any more than is necessary to get the deal done. So that would be principally the things I would be concerned about.
Okay. So yeah, because yeah, I've like I said, I'm not involved in esports, and I'm kind of with you. You know, if I ever had kids, I would want them to have other options. Esports is growing, but I've heard of a lot of the complications that the players are running into, and being that most of them are young, they don't. Most of them are not going to have the knowledge to navigate, these contracts, the legal system. They're like you said, they're pretty much presented with a contract, an opportunity. At that age, you're like, someone sees me, there's an opportunity. I want to take it. I want to hit the stage and, do what I love and become famous. But yeah, I agree. Like, prioritize the education first and then see what opportunities come your way. But the esports thing could definitely be an entire episode in and of itself. But I know for the gaming community and myself personally, there are some questions that have been bugging definitely me and some of my friends for years. And especially when it comes to publishers and how games are handled and IPs and terms of service. So let's dive into that a little bit. First, I would like to talk about copyrights and patents. And I know a lot of people hear those terms, but don't quite understand the difference between the two or exactly what they mean. So, could you elaborate a little bit about the difference in gaming with copyrights and patents?
Yeah, sure. So, and I'll even go a bit beyond that. Basically, there's four categories of IP. As you mentioned, you could say patents is sort of the first because of the level of protection that patents provide, and how hard it is, and to get a patent. Patents protect useful inventions, and that obviously typically has meant physical, tools, machinery, devices, etc. But in recent years, software patents have, of course, become a very important IP aspect. And so, what you're protecting there is the actual implementation of a concept, not protecting the actual concept itself, but it's a method, it's a device, and so forth that can be either digital or can be physical means. And I think they'll probably need to discuss that a bit more here later in the episode. But copyright, then, on the other hand, is typically a written work. It's artistry of some kinds, a photograph, audiovisual work. And in that case, you're protecting the expression, the actual expression against copying. In theory, copyright only protects against copying. So, if I were to independently conceive of the whole, World of Warcraft universe without ever having, referenced the actual World of Warcraft game, then in theory, that would not be copyright infringement. In reality, of course, in most cases, the rights holder is able to show that there's been some connection between the, infringing creator and the original work. So then the third category we have is trade secrets. And trade secrets are interesting because they're not actually registered with any government agency like patents and copyrights are. Trade secrets are just, confidential, proprietary, useful information that companies, typically companies, could be individuals, just keep internally, protect them from being disclosed, and then, have some value in their business. And the example that's always given of trade secrets is the recipe for Coca-Cola. It's never been copyrighted. If it was copyrighted, they would need to disclose it, and the protection would run out after a certain period of time. So at some point in the distant past, someone made the strategic decision not to copyright that recipe and just to maintain it as a trade secret. And then finally, you have trademarks. And of course, trademarks protect branding, they protect logos, company names, video game titles in some cases, and characters as well. Characters can be covered, and all kinds of IP can be covered by multiple of these four categories. Characters is an example. Character could be covered by copyright. It's the unique design of the character. It could be covered by trademark as well if that character is used to, basically sell a product or service.
Kind of like Mario for Nintendo and their mascots. Well, so many games coming out and so many developers coming up and creating original concepts and these established publishers like Nintendo, Microsoft, and Sony having their own products. How are developers supposed to be able to navigate knowing if they're going to wind up copyright infringing on something that they thought was an original idea?
Yeah, it's a great question. And this has been, you know, copyright infringement in video game content has been a sort of evolving space legally. And it's been somewhat controversial because, you know, rights owners in some cases believe that the creative content that they believe they ought to be have exclusive rights to that they've developed should be protected, and courts may say no, it's not protected under copyright. We don't find that it's original. We find that it's perhaps kind of what they call sains affair, French term, which essentially means if it's something kind of like a stock character, a stock scene, something like, example that's often given is, you know, a dungeon and a, damsel in distress or whatever,
Mhm.
and or horde of zombies in post-apocalyptic landscape. These are considered to be concepts that are not protectable because they're really just kind of standard for a particular genre. And then on the other hand, you have developers that don't believe they should be constrained if they're building, let's say, some kind of match 3 game or a game involving blocks falling from the top of the screen as an example. They may feel that just because there's some other game existing out there that has similar game mechanics doesn't mean that I shouldn't be able to build a new interesting game with my own sort of embellishments on that concept.
Okay. That explains too, like why so many battle royals are able to constantly be churned out every year. So talking about patents, one of the things that I know has been a hot topic recently was an example, the patent that Warner Brothers had for the Nemesis system, which basically, if I'm understanding this correctly, and correct me if I'm wrong, I believe it was for 10 years, it prevents developers from creating anything like that system because nothing before it existed I guess in a way. What would make a developer decide to go, in your opinion, with a patent route for something that they could probably easily market out to other companies and make revenue off of, especially if they're not going to use it, like Warner Brothers, because they used it, I think, twice and then they ceased to use it.
Yeah, I think this is a really controversial area, I would say, in games and just in software generally. And we've seen it play out largely over the last 20 years, where we had this period of time where the patent office was granting patents just like crazy in the early days of the internet and computer graphics and computer games. And I'm sure you've seen the examples. There was a patent granted for, I don't recall the publisher, but a driving game in which there is an arrow kind of hovering at the top of the screen that tells you which way to turn. I mean, how could that, does it really make sense that that could be like tied up for
Yeah.
20 years that no one else could? And in theory, I mean, the technology and the UI has kind of moved on since then, so it's not really an issue. And I think that particular patent's expired anyway. Yeah, you see, you have that, and you have, like another famous one in the game space is the patent that applied to mini games during the loading screens. Loading screens used to be a thing, so there's another example where there's another development of technology basically made previous patents kind of, you know, not relevant so much because we don't really have loading screens now. That patent has expired, and you can now go ahead and have a mini game while the main game is loading. But yeah, patents, in theory, the Nemesis patent protects a series of several patent claims. And it includes a hierarchy of the NPCs. It includes the ability of those NPCs to learn from previous interactions and a variety of other things. In theory, you as an independent developer could go out and you could you could use portions of that concept, and you could create your own kind of version of that. And in theory, again, you should be fine. But in reality, and this is one reason why these large companies, Nintendo, Sony, etc., why they have so many hundreds, thousands of patents, is that patent provides you with a real sort of a big tool, in the form of patent litigation. It could take, maybe you go out and you build your own version of Nemesis, and your patent lawyer says, you know what, I think this is different enough from WB's technology that you should be safe. But in the meantime, it could take a year, 2 year, 3 years of litigation to get to a resolution there. Maybe that resolution is in your favor, but it could be millions of dollars in legal fees to get to that point. So that is a real kind of, that's the club of having a patent. You protect what IP is legitimately yours under the patent law, but you also have this sort of interorum ability to kind of scare other people potentially who may be sort of stepping close to that line.
That's what I was gonna say. It's a good competitor suppression in a sense, because you it winds up becoming more of a headache to try to get your different version of something out there than it's probably worth in the end, and it might cost you way more money than your entire project, and probably just to wind up in court anyway at the end of the day. So yeah, I was also wondering too, do you think that patents were getting approved left and right because I'll say probably in the last 20 years and a little before, video games weren't taken as seriously until recent years. I'll say like the last 20 years, people have realized, and especially post COVID, just how impactful the video game industry is. So do you think that patents were getting approved because the people, they were thinking, it's just a video game. It's not that serious. No one's going to really care.
Absolutely. No, I think that's a great point. The video games industry, despite being, even 20 years ago, being, pretty big and pretty influential, it's just for whatever reason, it's taken a while. And even today, it doesn't really have the recognition that it has. This is a form of entertainment that's significantly larger than Hollywood at this point in the United States. And some of the brands that have originated within the video games environment, the context of video games, obviously have gone on to produce some of Hollywood's greatest hits in recent decades, as well as to expand into all different forms of media and to really become part of the kind of cultural landscape in the U.S. and globally. It's an industry that still does not have the kind of respect that it deserves, I would say, among different sectors within the broader business and government community.
I definitely agree. I feel that a lot of people don't realize not only, you know, video games has gone beyond just being a hobby these days. It's not only impacting its own growth, but other media as well, movies, television, music, it's creating inspiration across the world. So yeah, um, definitely a lot more respect is due to the video game ecosystem. Okay. Now moving on to something that does affect gamers directly. Let's talk about terms of service. Wonderful thing that everyone gets now before they can even boot up their games. One of the first questions, and I know it's been a hot topic for the last couple of years, was coming down to, do us as consumers and players own the games that we buy. And I've been a firm believer, and I'm also guilty of not fully reading the terms of service. It's a lot of print, but I do try to read certain sections of it to try to get an understanding of it. But can you elaborate just how important the terms of service in video games today is?
Yeah, well, so especially now with so much content and so much, so many products and services now being offered on the internet. I mean, we're just besieged as consumers in the US. We're just besieged by legal verbiage. We're buried in it. And, it's kind of a fiction. This is just kind of my personal opinion here, but it's kind of a fiction to say that, hey, we put, in the 6, 8, 10 pages of text that you agreed to by clicking that box, um, you know, you know, whatever's in there, you're responsible for. And we actually had not too long ago a U.S. Supreme Court justice who admitted that he had not read the documents that I'm sure he didn't, read the terms of service for whatever game he was playing. But he admitted he had not read the documentation that he signed to purchase this house. I mean, who does? How can you make it through all that? Certainly, it's fundamentally a disconnect between the expectation of the consumer and the providers of these services and products, including games. So that's my own personal soapbox. But speaking as a video games lawyer, these terms generally have been held in the U.S. to be enforceable. In the EU, we have kind of a different situation where there's restrictions and there's further requirements on what has to be or what can't be in those terms of service, and a broader range of situations in which a court will say, you as the user are not responsible for what was put in the terms of service by the game publisher. But in the US, those cases have been pretty infrequent, and usually they've involved really bad factual situations where someone was seriously injured or whatever it is, and the court doesn't want to hold against them, and the court says, it's unconscionable that these terms of service should be applied to you in this way. And so, but yeah, as a general matter and as a gamer, we are responsible for what's there in that terms of service.
So, what, and now that you've mentioned that they can be different based on country, what are some, I guess you could say, standard things in the terms of service that us as the consumer should we should at least read for our own knowledge and protection?
Yeah, I think, the vast bulk of this legal stuff is going to be the same. It's generic from game to game. And, I suspect that most or virtually all of these terms of service, even for AAA games, started as a copy of someone else's terms of service. So they have a lot of similarities. But I would say that, you want to look at refund policy. Probably I can, offer a newsflash here, which is that it's going to be very difficult to get your money back. But let's say, you're banned for some reason. What are those policies? What sorts of things could get you banned? Again, pretty predictable what the terms of service will say. There's broad discretion that the publisher has. But, what happens in that situation? Are you entitled to a refund, let's say? Are you entitled to port your data, or, whatever it is? So I would say, looking at those terms, one big one that actually, where there is some variation among different games, is user-generated content, or UGC. And that's just increasingly important in terms of an entertainment medium. And we still live in a world, and my firm, we do quite a lot of blockchain games, and some of these games, these creators, they're really trying to push the envelope on ownership of UGC. Obviously, that's one of the big advantages of blockchain games, or theoretical, at least at this stage, that you can own what you create, or you can be entitled to some compensation for that. But yeah, UGC, I mean, most games today, admittedly, are going to say whatever you create within our environment, we own, and you have no rights to that whatsoever. But of course, we are seeing in Fortnite, of course, Roblox was built on this concept of allowing users to create their own content and then to share in the value of that content within certain constraints. So that's certainly another area that I would want to look at.
Okay, yeah, because I do remember, I know, like, when you mentioned the user created content, Nintendo comes to mind because they're usually very tight knit about their IPs and, you know, people just creating content off of it. And that could be an entirely whole different conversation in itself. So, still in the same vein of terms of service, one of the developers that has recently made waves is Ubisoft. And implementing in their terms of service that if they cease to provide services or cut servers, that players are obligated to destroy all copies of their game, digital and physical. What kind of implications could that have on collectors who have physical copies that they paid for? Will they really, would Ubisoft, if somehow through the grapevine they found this random collector and said, you still have a copy of our game, The Crew, on your shelf, could they actually take that legal action against them?
So theoretically, I think the answer would be yes. As a practical matter, it seems quite unlikely it would do that, but it just highlights what we were talking about, which is sort of the kind of fiction that often results from these terms of service. I mean, I think whoever wrote that, and it's a really standard language, which, if I'm correct, has been in their terms of service for a couple of years at least. It says, if we modify these terms of service and you choose not to accept the changes, then you must immediately stop playing the game and destroy all copies of the game. I'm sure that that just went right past whoever was writing or reviewing that language because it's very standard. Well, of course, and I think they're probably usually thinking of, if you made copies.
Mm-hmm.
Don't know how you could really do that today, but certainly you could in the past. We don't want you to be able to say, oh, but the term of service didn't apply to this, copy that I made a year ago. Yes. I think that this is just really generic language. I think what you ask is an excellent question. You're a collector, and this is increasingly, of course, an important kind of thing. People's interest and affection for these retro games, and really, are you expected? So, I don't accept your change to your terms of service, and so then I have to go back and find these CDs, DVDs, and I have to destroy them.
And yeah, I have to destroy my collection to agree to these updated terms. It seems to me personally, it seems ridiculous. But it's good to know that a lot of people, hopefully, were just misunderstanding because the internet is like the huge telephone game. One person gets it, and then by the time it gets to the masses, it's been, you know, misinterpreted 100 times over. So by the time we get it, we're like, wait a minute, what's happened? You mean I
Right.
have to go back and destroy all of my video game copies? And it's like, no, no, no. Go read it for yourself. It was probably a misunderstanding. So yeah, guys, please read your terms of service for as long as you can handle. Try to find those critical sections and try to get some understanding for yourself. And if you aren't sure, please reach out to David. Like, the information directly from those that know what it all means. David, I really appreciate you coming on the show. There's so many things that we could go in depth with, and this could be like an entire series of itself. Like, I was doing a little research, trying to educate myself a bit on gaming law, patents, IPs, and I was like, wow, I had no idea how far it spreads and everything that is involved. But before I let you go, what would be your advice to indie developers stepping into the scene that are going to be, pretty much putting their game out there? What are some pitfalls that you've seen that you would like to try to help them avoid? Some things they need to know before they get out there?
Mm, yeah, well, it's tough. I mean, particularly if you don't have some credentials, some, work with a large, studio in the past and some kind of involvement with some IPs that, you know, potential investors in your game or publishers would be interested to see. But, we do see all the time, we see people come from nowhere in this space. The most important thing I would say is relationships. You got to have someone that hopefully, can get excited about your kind of demo and maybe, talk to their friends and maybe you get some angel investment to help complete a larger, more developed version. Eventually, connect you with the right people at a game publisher who, might be interested in your game. So I would say that's super important, but there's a whole range of things. I mean, like we were discussing earlier, copyright. I mean, you certainly don't want to be in a situation where, you know, publisher is concerned that what you've created is too similar to something else. And you also don't want to be in a situation where, your first investors come and take a look at the books and they're like, who are these? I see the names of some individuals that look like they were like creating some content or came up with some ideas, the title or the characters or whatever. Who are they? And you're like, oh yeah, there's some people that were working for me a couple years ago, and we never formalized an IP agreement or anything. I mean, that's a bad situation because then there's going to be a real concern that you're going to be able to a track those people down, B, that they're going to be amenable to signing retroactively, signing away their rights, particularly because they're going to be a little bit, their antenna are going to be up because they're like, why is he coming to me now? He's got like a publishing deal potentially. Maybe I should get a share of that, et cetera, et cetera. So IP in terms of the inputs to the game is something that we often see is overlooked by, early stage indie developers. You really got to have that documentation just like really airtight from the start because there's a million reasons why a publisher might reject your game or why angel investors may choose to pass and look at something else. And the quickest way to do that is for them to see, hey, here's an IP risk.
Well, David, thank you so much for your time. I know you're a busy man, but if anyone wanted to reach out to you, how could they contact you?
Yeah, thanks for asking. So our firm is Gamma Law, and we came up with that as GAM was games. The next M was media, and then the A we weren't really sure of, but these days we're doing quite a lot of AI work, so we decided that should be AI. But we're at gammalaw.com, and we have quite a lot of content there that I think could be helpful for developers. And we also have a monthly newsletter that's been pretty well kind of, I think, pretty successful, and people have told me they found a lot of value from it. Feel free to reach out through our website, and I'm also on LinkedIn, David Hoppe, Hopp.
Thank you so much. And guys, if you have any questions, please do not be afraid to reach out. There's so much information in gaming law. And if you're a gamer, it does affect you. I know it's easy to just sit down and want to just relax and play the game, but this will help you understand why certain publishers are doing the things they are, why certain companies are going in different directions. There's a whole lot of things that happen behind the scenes, and it would help if we got a better understanding of what was going on. So I definitely say go and check it out, join that newsletter, get the information, and educate yourself on it a little bit. But anyway, thank you guys so much for tuning in. You guys have been amazing. Take care of yourself and each other. Go check this out and leave your thoughts. gzchopchoppodcast.com. We'll catch all you wonderful people on the next episode. Later.